Hi guys, welcome back. Thanks for joining us for this week's episode. Today we'll be discussing the differences between attorneys and advocates, as there still appears to be some confusion in this regard. Before we start, please remember to hit that subscribe button and check out our social media pages. The links thereto can be found in the video description below. Qualifications, requirements, and formalities. Attorneys. I'm sure our returning viewers have heard more than enough times what the requirements and formalities are for admission as an attorney. In case you're still unsure, take note that in order to be admitted as an attorney, candidate legal practitioners must meet certain requirements. Namely, they must have the requisite degree, serve under a contract of articles, also known as a practical vocational training contract, complete the compulsory practical legal training, and pass the 4 admission exams. Once the above requirements have been met, candidates must apply to the High Court for admission. However, we're not going to go into depth here, as we've already discussed admission in extensive detail in previous episodes. In this regard, check out our series on articles of clerkship. Attorneys may also become conveyancers and/or notaries after complying with further formalities and passing the relevant exams. Advocates. As is the case with attorneys, an LLB degree is a prerequisite to becoming an advocate. Prospective advocates must apply to the High Court to be admitted and enrolled as such. The procedure is very similar to that of attorneys seeking admission, but for the sake of clarity, a person intending to be admitted and enrolled as an advocate must serve under a practical vocational training contract with an advocate referred to in 7 subsection 4 of the Legal Practice Act rules for an uninterrupted period of 12 months after that person has satisfied all the requirements for a degree referred to in sections 26(1)(a) or (b) of the Act. This is known as pupillage. And prior to or during service under a practical vocational training contract, complete a program of structured coursework comprising compulsory modules of not less than 400 notional hours duration in the aggregate over a period of no longer than 6 months. Take note that attendance at any training course approved by any existing society of advocates, the National Bar Council of South Africa, or the General Council of the Bar, for which the pupil registered before the date referred to in section 120 subsection 4 of the Act, and in respect of which the required attendance was completed within a period of 12 months after that date, is regarded for purposes of these regulations as compliance with the requirements of 7 subsection 1b. During pupillage, the bar provides training and learning opportunities to advocates, preparing them for practice and informing them about the professional standards and conduct among practicing advocates, and the code of ethical conduct and of professional integrity to which all advocates are required to adhere. After the year of pupillage, advocates are then required to pass the National Bar Examination of the General Council of the Bar before becoming a member thereof. In terms of the Legal Practice Act, advocates may now also apply to the Council to convert their enrollment to an attorney in terms of section 32 subsection 1a, or to an advocate with a trust account in terms of section 32 subsection 1b. Nature of work. Attorneys. An attorney is a person with whom you first make contact when you seek legal advice or if you require legal assistance. Therefore, attorneys need to be readily available to everyone, and the service they supply needs to be broad enough to cover a wide field of legal problems, unless of course the firm at which the attorney works specializes in a certain field. Attorneys handle a large variety of affairs for individuals, businesses, associations, and corporations. Most attorneys should be able to assist clients in the following areas of law, amongst others: business and corporate law, banking law, contract law, civil litigation, family law, property law, taxation, estate planning, and so on. Many attorneys consider themselves to be general practitioners. However, a lot of attorneys also specialize in certain fields. A specialized field can include, but is not limited to, maritime law, intellectual property law, mining law, environmental law, criminal law, aviation law, customary law, immigration law, mergers and acquisitions, and so on. Depending on the nature of the matter, attorneys' work may include the following: meeting with clients, opposing attorneys and counsel who are advocates, providing legal advice and/or assistance, drafting and perusing pleadings, notices, letters, and other documents, corresponding with clients, counsel, opposing attorneys, sheriffs, and so on, drafting contracts, conducting research, drafting legal opinions, registering companies, drawing up wills, administering deceased estates, administrative tasks, accompanying counsel to court appearances, arguing matters in court, provided certain requirements, which we touched on shortly, are met. Until 1994, only advocates were allowed to present cases in the high courts of the various provinces, which were known as the Supreme Courts, and the Appeal Court in Bloemfontein, now known as the Supreme Court of Appeal. Although attorneys may now argue matters in the various courts after meeting the necessary requirements, in most cases, advocates are still briefed to argue the matters instead. Attorneys may also qualify as conveyancers and/or notaries, provided the requirements therefore are met and the necessary exams are passed. Conveyancers specialize in the legal transfer of ownership of immovable property and the hypothecation of immovable property by means of mortgage bonds. They are experts in the preparation of the deeds and documents required by law or custom to effect such transfer or registration in the deeds registry. A notary public in South Africa is an admitted attorney who has passed a competency examination for notarial practice and who has been admitted as a notary public by the High Court. Notaries hold a respected office which is internationally recognized. Notaries may witness signatures, draw and attest contracts and statements, and authenticate the validity of certain documents. Certain documents are required by law to be notarially executed, such as ante and postnuptial contracts, deeds of servitude, deeds of cession of usufruct, notarial leases, trust deeds of donation, and notarial bonds. Advocates. Advocates, more commonly referred to as counsel, tend to have specialized expertise in various areas of the law, such as family law, banking law, etc., but are primarily experts in the art of presenting and arguing cases in court. Most advocates are also quite exceptional when it comes to drafting, whether it be pleadings, notices, heads of arguments, whatever. Due to the nature of work advocates do, their knowledge of the rules of court is above average. Advocates are essentially specialist litigators. They often act as mediators and/or arbitrators in such hearings as well. Advocates are not approached by clients directly unless they are trust account advocates, but are rather briefed by attorneys. This is discussed in more detail in a bit. Whereas advocates possess incredible argumentative skills, an attorney, on the other hand, would very likely be better equipped to draft a contract, for example. We're again speaking generally here. There are attorneys who are better at arguing than advocates. However, this does not take away from the fact that advocates are specialist litigators. Employment. Attorneys. An attorney may only practice for their own account, or as part of a juristic entity established to conduct legal practice, or as part of a law clinic, or as part of Legal Aid South Africa, or in the full-time employment of the state. Attorneys may also open their own law firms, provided said firm is a sole proprietorship or one of the juristic entities established to conduct legal practice. In other words, your firm cannot be a closed corporation. Well, nothing can anymore, but you get my point. Attorneys must bear in mind, however, that a lot goes into starting one's own firm. And as is the usual case with the legal profession, there are requirements and formalities which must be met and complied with. A newly admitted attorney usually takes the title of associate. In some firms, a distinction is made between junior and senior associates. Depending on the type of entity, associates usually progress to become partners or directors of the firm. Even attorneys who qualify as conveyancers and/or notaries may be associates, partners, or directors. Advocates. Unlike attorneys, advocates are not employed by law firms. The ethical rules for advocates do not allow them to practice in partnership or through a legal entity. Advocates render their services individually and take responsibility for their decisions in the course of doing so. Advocates may only practice for their own account and as such may not make over to, share, or divide any portion of their professional fee, whether by way of partnership, commission, allowance, or otherwise, as part of a law clinic established in terms of the Legal Practice Act rules, as part of Legal Aid South Africa, or as an advocate in the full-time employment of the state as a state advocate or the South African Human Rights Commission. In the public sector, State advocates are employed as public prosecutors by the National Prosecuting Authority, and some advocates are also employed as advisors in various organs of state or state departments. Advocates are generally referred to as either junior or senior counsel. The title of senior counsel does not simply come after practicing for a certain number of years. In actual fact, advocates only attract the status of senior counsel upon being appointed as such. Once appointed, senior counsel will bear the letters SC after their name. For example, Joe Dirt SC. Senior counsel are also known as silks. The reason why they are referred to as such is because their robes differ from that of a junior advocate. Many senior counsel have robes made out of silk, hence the name. Interesting, eh? Judges of the High Court are often appointed from the ranks of senior counsel. There are a number of interesting differences between junior and senior counsel, so I'd recommend reading up on the topic. Relationship and interaction with clients. Attorneys. Attorneys and their clients deal directly with one another. Should the client be a juristic entity, a representative thereof will communicate and engage with the attorney on behalf of the entity. The relationship between attorneys and their clients usually comes into existence due to clients requiring legal advice or assistance. In this regard, the client will normally contact the attorney telephonically or via email to arrange a consultation. Due to COVID, it is becoming more common to hold consultations and meetings virtually. At the initial consultation, the client will be asked to give the attorney a brief description of the reason for the consult. The attorney will ask questions in order to establish the nature of the client's legal issue, the client's legal options, whether the attorney can in fact assist the client's prospects of success, and the estimated amount of work that will be required to attend to the client's instructions and the estimated costs associated with such work. It is at the consult, or even prior thereto, where the attorney should provide the client with their fee structure, so as to avoid later disputes over invoices. Take note that not all attorneys conduct their consultations in the same manner. Once the initial consultation has taken place, the attorney will attend to the necessary to fulfill their mandate. During this time, the attorney should be in regular communication with the client for purposes of keeping the client updated. The attorney may also need to have additional consults with the client, depending on the nature of the matter. Further consults may also be inclusive of the advocate briefed in the matter. Again, depending on the nature of the matter, the client may need to accompany the attorney to court or attend the attorney's office to depose to affidavits, etc. Advocates. Historically, advocates were not permitted to be approached directly by clients. Clients would instead brief an attorney, who would then approach an advocate if necessary to argue the case before a court. This was known as the referral system. In terms of the referral system, all communication by the advocate would be addressed to the attorney and not to the client directly. The attorney would relay the information. Even where the advocate requires a consult with the client, the attorney would need to be present. Essentially, an advocate's client would be the instructing attorney, whereas the attorney's client would be the client themselves. Since the operation of the Legal Practice Act, however, advocates may take instructions directly from clients, as opposed to from attorneys only. In order to do so, they must be registered with the Legal Practitioners Fidelity Fund and operate a so-called trust account practice. In order to do so, they must be registered with the Legal Practitioners Fidelity Fund and operate a so-called trust account practice. Every attorney and every advocate who operates a trust account practice must be in possession of a Fidelity Fund certificate. As it currently stands, there is not a huge amount of trust account advocates, but it's still early days. Right of appearance. Attorneys. Candidate legal practitioners may appear in the district courts and, after serving 1 year of articles, the regional courts. Upon admission, attorneys do not have the inherent right to appear in the superior courts, which is the High Court, Supreme Court of Appeal, and the Constitutional Court. An attorney who wishes to apply for the right of appearance in the aforementioned courts must apply to the registrar of the division of the High Court in which they were admitted and enrolled as an attorney for the issue to them of the prescribed certificate. The application must be in writing, must be dated and signed by the attorney, and must be accompanied by documentary proof that they have satisfied all the requirements for a degree referred to in Section 26, subsection 1 of the Act, or any other degree which, before the date referred to in Section 120, subsection 4 of the Act, would have entitled the applicant to the right of appearance in the High Court, the Supreme Court of Appeal, and the Constitutional Court. A certificate issued by the Executive Officer of the LPC to the effect that the applicant has been practicing as an attorney for a continuous period of not less than 3 years, or for an aggregate of 3 years during the previous 4 years, or has been practicing as an advocate. A certificate issued by the executive officer of the LPC that the applicant has not had their name struck off the roll and has not been suspended from practice, and that there are no proceedings pending to strike the applicant's name from the roll or to suspend them from practice, and a certified copy of the applicant's ID. Therefore, attorneys are required to have at least 3 years post-admission experience before they may appear in the superior courts, subject to the following. If the attorney wishes to apply for a reduction in the prescribed period of 3 years, they must provide the registrar with a certificate by the executive officer of the LPC that they have undergone a trial advocacy training program approved by the LPC, and that the LPC has resolved that the 3-year period referred to in that section be reduced to such period as may be specified by it. Or, if an attorney wants to receive right of appearance before the expiry of 3 years due to them having gained appropriate relevant experience in a shorter period, they may apply for the prescribed certificate. Full details of the attorney's experience must be set out in the application. The applicant must serve a copy of the application on the LPC not less than 30 days before they apply to the registrar. Every attorney who was, prior to the Attorneys Act being repealed, in possession of a certificate issued in terms of Section 4, subsection 2 of the Right of Appearance in Courts Act must have, within 6 months of the date of coming into effect of the LPA rule pertaining to rights of appearance, lodge with the LPC a copy of the certificate issued to them in terms of that Act. In essence, attorneys with right of appearance before the implementation of the LPA retain their right of appearance. Take note that it is only appearance in the superior courts which requires further requirements to be met by attorneys. Therefore, attorneys may, upon admission, appear in the Labour Court, Land Claims Court, Equality Court, and so on. Advocates. Any advocate shall have the right to appear on behalf of any person in any court in the Republic or before any board, tribunal, or similar institution in the Republic, unless their name has been ordered to be struck off the roll, or they are subject to an order suspending them from practice. Advocates' right to appear, as mentioned above, is acquired automatically upon admission. Regulatory bodies. Attorneys. The Legal Practice Act regulates the profession of practicing legal practitioners. The term legal practitioner includes both attorneys and advocates. Until recently, attorneys were regulated by the Attorneys Act, but in November 2018, the Act was repealed and replaced by the Legal Practice Act. The Legal Practice Act falls under the authority of the Minister of Justice, but for all intents and purposes, the policies and purpose of the LPA are implemented by the LPC and its provincial branches. The LPC and its provincial councils regulate the affairs of and exercise jurisdiction over all legal practitioners, both practicing and non-practicing, and candidate legal practitioners. The LPC is a statutory regulatory authority and does not have members like the previous law societies had. The LPC is mandated to set norms and standards, to provide for the admission and enrollment of legal practitioners, and to regulate the professional conduct of legal practitioners to ensure accountability. Advocates. As mentioned above, the LPA applies to all legal practitioners. As a result, the Admission of Advocates Act has been repealed. The term legal practitioner includes both attorneys and advocates. All legal practitioners are regulated by a single independent body, namely the LPC. The regulatory functions of the advocates' bar councils and associations with regards to training, examination, and disciplinary functions have now been transferred to the LPC. We are of the opinion that we're moving in the right direction with this. Offences. Attorneys. Conduct of attorneys which constitutes an offence as per the Legal Practice Act. Sharing professional fees with anyone other than another attorney. Attorneys who operate as trust account practice and who practice for their own account, whether in partnership or as a sole proprietor or as a director of an incorporated practice, must be in possession of a Fidelity Fund certificate. It is an offence not to be in possession thereof. Should an attorney not be in possession of a fidelity fund certificate, it is an offence for them to receive money or property into trust, in other words, hold it on behalf of someone else. An attorney who, in a practice without the written consent of the LPC, employs in any capacity any person who has been struck off the roll or suspended from practice while that person remains struck off or suspended, commits an offence and is liable on conviction to a fine or imprisonment for a period not exceeding 1 year. An attorney commits an offence if they breach the provisions of Section 34 of the Legal Practice Act, which concerns forms of legal practice. Should such a breach occur, the attorney will be liable on conviction to a fine or to imprisonment for a period not exceeding 2 years, or to both such fine and imprisonment. An attorney who contravenes Section 56 subsection 7 with regards to receiving funds in trust account commits an offence and is liable on conviction to a fine or to imprisonment for a period not exceeding 2 years. An attorney who contravenes Sections 84 subsection 1 or subsection 2 or Section 34, which involves handling of trust monies in rendering legal services, commits an offence and is liable on conviction to a fine or to imprisonment for a period not exceeding 2 years, or to both such fine and imprisonment, is on conviction liable to be struck off the roll, and is not entitled to any fee, reward, or reimbursement in respect of the legal services rendered. Advocates. Conduct of advocates which constitutes an offence as per the Legal Practice Act. An advocate who is not a trust account advocate may only provide legal services for remuneration upon receipt of a brief from an attorney. It is an offence to breach this provision. It is an offence for trust account advocates to not be in possession of a fidelity fund certificate. An advocate is not permitted to share their professional fees in any way with anyone else and commits an offence if they do. Not only attorneys, but an advocate also commits an offence if they breach the provisions of Section 34 of the Legal Practice Act, which is forms of legal practice. Should such a breach occur, the advocate will be liable on conviction to a fine or to imprisonment for a period not exceeding 2 years, or to both such fine and imprisonment. A trust account advocate who contravenes Section 56 subsection 7 with regards to receiving funds in trust account commits an offence and is liable on conviction to a fine or to imprisonment for a period not exceeding 2 years. Guys, these offences are in terms of the Legal Practice Act. An attorney who goes out and murders someone is also guilty of an offence, just not in terms of the Legal Practice Act. We hope that you now understand fully the differences between attorneys and advocates. Although both are referred to as legal practitioners now, their roles mostly differ. Please, if you enjoyed this video, hit that subscribe button and share this channel with your friends. We're also on Facebook and Twitter, so give us a follow there too. The links are in the description. Our website is also currently under construction. Also, if you have any episode ideas, let's hear them. Ciao.